The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones. I'm a Wisconsin family law attorney with O'Flaherty Law, and today we're going to do a how-to video for filling out Form FA-609, Notice of Hearing and Motion to Enforce Physical Placement Order. So this video is for educational purposes only, and it is not legal advice. If you are running into a really sticky situation post-judgment, you may want to consult with an experienced Wisconsin family law attorney to assist you, but this video is just to help walk you through the form that's available on the Wisconsin Circuit Court website. And with that in mind, we'll jump right into it with kind of an explanation of why you would use this form. So this is a post-judgment form. It's even in the post-judgment section on the website. And what that means is that a judgment has been entered in regard to your marriage or in regard to a paternity case. There's a physical placement order signed by a judge. You've got a copy of it. It lays out exactly where that child should be at any given time. And the other party is not respecting the order. So we'll start off with the top left-hand corner of the form. You would just put your name and the name of the other party. And then here, you want to put in the county that the original case was filed in. So whatever county you got divorced in, or whatever county you had your paternity case in, you're going to bring it in that county. And you shouldn't be, if you moved, don't go. If you lived in Dodge County and you moved to Waupaca County, don't file it in Waupaca. File it in Dodge. This top right-hand corner of the form is a no-fly zone. This is just for the Clerk of Courts. Don't put anything on here. Don't be strange and staple it on the top right-hand corner here. Just leave this completely alone. This is not your area. This is the Clerk of Courts area to work their magic. Then you would put in the names of the parties and all their contact information. And because this is a post-judgment motion, you're going to use the case number you had in either your divorce or your paternity case. And if you have a copy of the order that you're trying to enforce, the case number should be on it. And for some reason, if you can't find it, you can always look your case up on Wisconsin Circuit Court Access Program. You can search by name and you can find your case. Let's talk a little bit about the title. As I've said, it's a post-judgment order, so there should already be a physical placement order entered into the case. Anytime you file a motion with the court, that is you asking the court for something. It's not a pleading, it's a motion. And on most motions, I don't want to trip over my words there, you need to have a motion hearing. And that means that you have to notice the other party that there's going to be a hearing. So you start with the notice of hearing to whoever you're moving against, the other party. And the clerk will complete this section for you, but this is where they will put the time, the place, and who's going to hear your motion. So just leave it blank for the clerk. Then comes a warning. Failure to appear could result in an order being issued granting the relief requested in the motion. A copy of this notice and motion shall be personally served on the other parent not less than 5 business days prior to the hearing. So once you've got a hearing date up here, the clock is ticking. You've got to get it sent, you've got to get it served on the other party as soon as possible. And frankly, it can't be publication and it can't be mail. You've got to hire somebody to hand it over to them, or you've got to give it to them yourself. Something. You've got to have proof that they were personally served. Someone who can fill out an affidavit of service and file it in the case would be ideal. If the moving party seeks to have you found in contempt of court for non-compliance with the judgment or court order, because remember, we're looking to enforce a judgment or court order, and if you are found in contempt of court, a jail sentence could be imposed. You therefore have the right to be represented by an attorney at this hearing. Unless good cause is shown, failure to appear with an attorney may be considered a waiver of that right. So this is a very serious thing, because if you're moving to enforce an order, that means the other side isn't obeying the order. And you know what? Courts don't like it when people do that. They get really angry. Well, not angry, but they're very intolerant of it. So that's why there are all these potential penalties for not complying with the order that the judge signed. So if anybody really requires reasonable accommodations due to a disability, the court website in the county that you're filing typically has the number you need to call for accommodation posted on their website, and you would just put that in here. Or you could ask the clerk when you file and get your hearing date. Or before you file, you're standing in line at the courthouse, you're about to talk to the clerk, you just tell them you need the number to put in here. Or you could also just call them prior to going in and get the number. They're usually very helpful. So you do need to put in that number there for any reasonable accommodations due to a disability. So that is the notice part of the notice in motion. Moving on to the motion. So you're asking the court for something. You want relief. You want this order enforced. So starting at number 1, based upon the following, I was awarded periods of physical placement of, then you list the children, by judgment or order of, then you list the county, and you attach a copy of the physical placement order. You've got to have a copy of the order you're trying to enforce. Have it next to you when you're filling this out. 2, I have had one or more periods of physical placement denied by the other party. B, had one or more periods of physical placement substantially interfered with by the other party. Like they were supposed to drop off at 3, it's 10 o'clock, they're still not here. They are cutting into your court-ordered time with your children. And C, incurred a financial loss or expense as a result of the other party's intentional failure to exercise periods of physical placement without adequate notice under an order allocating specific times for the exercise of placement. Parent 1 was supposed to pick the kids up at 6 p.m. on Sunday. By 9 a.m. on Monday morning, they still had not picked the children up, and you had to call into work. You couldn't go into work because you had to stay home and watch over the children. That would be an example. So here's the nitty-gritty of it all. Here's your chance in paragraph 3. The facts explaining what happened are. And of course, there's not enough room here to explain much of anything. So you're going to click See Attached, and you're going to open a Word document or do an extremely neatly written, handwritten if you have to, explanation on what is going on. And the clearer and more concise your explanation, the better it's going to go for you. It's very important when you're writing these explanations not to wander, not to sit and personally attack the other party, even though it's tremendously tempting. Stick to the facts. They were supposed to drop the children off at 5 p.m. on Wednesday. They didn't show up. You called them, you texted them, they didn't answer. You're frantic, you're wondering if something has happened, that kind of thing. And additionally, not only do you need a well thought out and well worded explanation for why you need this relief, but any kind of proof that you have to back it up will only help you. That could include text messages from the other party saying, well, I'm just not going to do it, or, I'm not up for it, or I don't want to give them to you, or I don't think they're safe with you. Things of that nature, you would want to print out and attach, because the more explanation and proof you can give the court, the better job you'll do sharing your side of the story. So that is where you give your reasons and the facts of what happened. Next, you request your relief, because that's what a motion is really all about, getting the court to listen and to grant you some relief. So, 1, grant additional periods of physical placement to replace those denied or interfered with. Not unusual at all. If parent 1 has been denying parent 2 visitation, especially over an extended period, the court's going to look to remedy that and to get you that adequate time with your children, meaningful time with your children. The court will award reasonable costs and attorney's fees. You have the right to costs and attorney's fees because the other party disobeying the order that is in place has created a situation where you have to go to court for relief. Then we have some options here. Depending on what applies to you, what is your situation? What are the facts and circumstances? You can require that the other party return the child to me. Maybe somebody picked up the kids for visitation and just decided not to return them. 4, change the current order to specify the times for the exercise of periods of physical placement. Sometimes married couples who get a divorce, they leave things pretty loosey-goosey when it comes to visitation, because they were getting along at the time, and then something changes and they need more structure. And the court can provide that. 5, you can ask the court to find the other party in contempt. If it's bad enough, you can ask definitely, if you think contempt is warranted, you need to ask for the court to find the other party in contempt. 6, grant an injunction ordering the other party to strictly comply with the judgment or order. It seems like it would go without saying, wouldn't it? But you can get an injunction. If they're really just not towing the line, you can definitely ask for that. 7, require the other party to pay me a sum of money sufficient to compensate for financial loss or expenses resulting from the other party's intentional and unreasonable failure to exercise periods of placement under an order that allocates specific times. So, like the example I gave earlier, if they were supposed to pick the kids up at 6 o'clock on Sunday evening and it's the next day, 9, 10 a.m. on Monday, and you're missing work because you haven't planned to have the children with you, you have nothing in place for them, then that would be something you could ask for. But the thing is, with number 7, 2 things. 1, there needs to be an order that allocates specific times. So again, if you have one of those more flexible orders that doesn't allocate specific times, you're probably not going to get it. And 2, you're asking the court to order the other party to compensate you. So anytime you ask the court for money, you need to be specific on why you're asking for the amount you're asking for. So say you're asking for $500 because you bought train tickets for the kids to come visit you and the kids just never showed up. So you would need to provide the court with proof that you had purchased those tickets. That would be something you would need to provide to the court with your motion. And the more proof you have that you're out money because of their behavior, and I'm not talking about proof that you just wrote in a story. I'm talking about receipts, emails, text messages that support the fact that you're out money, anything and everything you have to show that they put you in a position where you were damaged financially. So now you hit a stop sign. You're almost done. You've got your evidence. You've asked for relief. You've got your order attached. You've got your exhibits attached. And now it says stop. And it says take this document to a notary public before you sign it. So in other words, you just need to sign it in front of a notary. The notary will look at the document. The notary will not look at all the details of the document. The notary will verify what the document is. The notary will verify your identity. And then the notary will watch you sign it and they'll put their stamp on it. If you're worried about finding a notary, your bank or credit union almost certainly has one around for you to use for free. Sometimes they do require that you make an appointment, but that's not such a big deal. Or I know the UPS store offers to notarize documents for $5 a pop, which is pretty affordable. But again, just don't sign it unless you're in front of a notary. Otherwise, you're going to have to do a fresh form. So again, don't modify the form. Every single form that's available on the Circuit Court website, don't modify them. They are very specifically formatted to be acceptable to the court system and the state e-filing system. You can supplement with additional material all you like, and that is the separate pieces of paper with your facts and circumstances explained. That is your exhibits. That is the order that you're asking to be enforced. It's all additional material that you use to supplement. Just don't add lines or mess with any of these boxes on the side or try to put in notes underneath a request. Don't do any of that. Just leave the document as it is format-wise. So that is how to fill out a notice of hearing and motion to enforce physical placement order, otherwise known as FA-609. Thank you so much for listening. To learn more about post-judgment actions and divorce law in Wisconsin, you can visit our page. It's linked below. Be sure to leave any questions you have in the comments section and subscribe for more legal content daily. Again, thank you, and I wish you the best of luck with your matter.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.